first topic of the night is, of course, lien to persons. So we have the concept of the secured party creditor. Well, we want to go through, of course, secured party. We want to go through creditor. Now, we've found in Black's Law and different areas, we've found secured creditor, we've found secured party, but nowhere can we find a definition for the term secured party creditor. In my eyes, I believe that it's something that's been kind of coined during the movement to help facilitate and personify some of the actions that are taking place so that one would be able to relate a little better. And I think a lot of the concepts and spiritual context that Brandon has brought to the table, though it's very grounding and very foundational, individuals can tend to run with it in a different way. And some people will take paperwork that has been, clearly documented as sample work with, with clear mistakes in it, and take it on as their own and use it as if it were, paralegal documentation or something of full substance without fully understanding it. The secured party creditor, I think, was one of those terms that were kind of coined and kind of ran off in that sense, where it was shown in documents and it was being shown to kind of use it, or kind of being used to show a theory, and I think people kind of took it on as their own. In terms of speaking with law enforcement, you'll hear Gordon Hall say things like that. I'm the priority security interest holder in the estate known as, and all of those things can be real, but there's the issue that Gordon and his friends always run into, which is the judge is always standing there looking at the individual saying, I'm here, I'm not the name, I'm here for the name. And you're immediately placed into a conundrum where you have to literally spend more energy attempting to identify the parties in the contract than you would ever have to actually take care of the issue. If you were to get past that issue, it could probably be much smoother. So that's kind of the concept basis that we want to present tonight is, what if there was a legitimate individual representing your will and testament on behalf of the living man, so that the living man does not have to be confused with the taxpayer that is actually being charged.
There's a lot that goes around the secured party creditor, the concept, that is. So if we're talking about this conceptually and not just the definition of secured party creditor, let's put it in a little bit of context. I think most members of GTEN know this history I'm about to talk about, but maybe not everybody. There was a movement kind of back a couple of decades ago called the Patriot movement, and it was people who were studying hard and learning concepts and finding that they had rights that had been potentially buried, or that they had agreed to sign away, and at times they were called constitutionalists. They went back to the founding documents, and they tried to stand on the Constitution, and it didn't work out all that well. I mean, we owe a debt of gratitude to these people, these pioneers of this information, because they opened the doors of perception to a lot of people. But a lot of them wound up in jail for tax evasion and things like that. Following on that, there was sort of a sovereignty movement, and the sovereigns, realized that there's nothing between them and God, and the federal government included, and the sovereigns sort of were a softer version of the Patriot movement, I guess, sort of studying just as hard and taking a slightly different approach. And with the advent of some new minds and new ideas in it, the whole thing sort of came into the creditor movement. And I don't know who first coined that phrase, but I first heard it from Brandon Adams. I don't know if he invented it or what, but creditors in commerce. He, made a point of defining what he means by creditor, and pointing out that we're led to believe that we're the debtors, or our persons, our ens legis trust estates, are the debtors in the system, and the banks are the creditors. And sort of the focus of this movement was to put a spiritual understanding into it, that we are the creators. Okay, we are the creditors. We are it is the individuals through their persons that can create money into the system, for example. It is the individuals through their intentions and thoughts and observations that turn any sort of energy in this material realm from primordial energy into matter, space, time, into the experience that we have, and we get in this material realm exactly what we intend as a group. Okay, so there's a lot that goes around this word creditor. It comes from creator, and it has been recaptured through the studies of people for decades here. It has been recaptured as and redefined, in addition to just the fundamental definition of it that might appear on a UCC1 financing statement, and how you would use it there. Okay, so it's a loaded word, and there are myths that go with that. There are creditor myths that people believe things that aren't true. There are people that don't understand where the truth is, and it's a complex issue around this word. And secured party creditor, I think, complicates it even more, because, like PJ said, you can't look up secured party creditor anywhere that I know of. You can look up secured party, you look up creditor or secured creditor, but I don't know where you find a definition for secured party creditor.
And so I believe someone asked a question: how does one become a secured party creditor? And
That's exactly what I'm talking about.
you
That's
know, and
yeah.
this is a really simple understanding. If one loans money to someone and deems themselves insecure and wishes to have collateral to ensure payment and performance of that debt that's been incurred, they become a secured party and they become a creditor in the same light. Question answered.
Right. Creditor, or secured party, which is essentially the same thing, or very, very similar in definitions, are they mean that there is an obligation, for which, in the case of a secured party at least, there's collateral, or there's a right to collect, or both. Simple as that. And the other many uses of the word, I think, have maybe a time and a place, but this call probably isn't the time or the place. This webinar probably isn't the time or the place. This is truly talking about the secured party in an agreement, as listed as public notice on a UCC1 financing statement. We're talking
Very
about yeah, we're talking about someone who's actually owed something.
That's correct. That's correct. So, let's move on to the next slide here for a moment. The myth of distinguishing the living man from the person with a UCC financing statement.
Well, yeah, couldn't have walked into that one any better than everything I just rambled about, right? I mean,
Right.
I didn't even realize that was the next thing that was popping up here. um,
No worries.
it,
So,
You want to take that? I've
Well,
been
I could
talking
start it off, but I'm sure you're going to put your own spin on it too.
most
So
likely.
yeah, yeah. So we're talking about the secured party creditor, right? So we're talking about leaning the debtor for a debt owed. Well, in that creditor movement, there was the theory that since the living man is not the person, and the living man creates the energy, then there is a transmittal or a transfer of energy that can be documented, valued, and assessed, and can be accounted for from the living man to the person. And when going to yourself, well, if I've never been the person, well, I've been giving the living man, or I've been giving the person, the living man stuff all my life. And, he owes me his life. That person owes me his life. So then the idea comes to say, well, since there's a debt, well, we're gonna put a value on what I believe is, we'll say 30 years of the person's life benefiting from the energy of the living man, and I'm going to put a lien against that in the name of the living man as the secured party and the person as the debtor. Now, there's an issue with that. The issue is that no living man, that is when we refer to each other spiritually as I am, or that which was the fount of honor, right? You guys can look that up. So the we look at ourselves as this being. That being cannot exist in commerce. The only thing that exists in commerce are fictions, if I'm not mistaken. Correct me if I'm wrong, please. And those fictions are able to then sue, be sued, and do any kind of business with each other that they choose. So wouldn't it be logical to represent the living man's will and testament in a legitimate special purpose vehicle or organization that can respectively carry out and execute the duties of the living man in commerce as a fiction? Because the living man is just going to cause you problems when you go in and I'm not the person, I am, that is PJ, and I'm the priority security interest holder because I have a security agreement with the straw man and the living man that states that it owes me, let's say, $300 billion. So you could see where a judge would just look at you and go, are you even fit to be here? How about a competency hearing? Like a competency hearing might be really good for you right now. Or maybe I'm going to assign you an attorney because I don't think you read the local rules of court. I don't think you read the state rules of court. I don't think you know what kind of venue you've entered into and what you're doing here. So I'm going to look out for your best public interest, and I'm going to assign you what I think is best for you. And that's what judges will always do, because the living man that's walking in, they look dual-minded. They claim they're not the person that they're there to represent, but there's no distinguishing factor to prove it. And they may be Gordon Hall himself, the best person, but I guarantee you Gordon Hall gets some freaking flack for it. He may be able to pull it off every time. But is he every other person? And is every other person going to be as distinguished or as eloquent or as well endowed with knowledge as Gordon Hall is? Well, we hope to all get to that point, but in the moment of practice, isn't there a step that seems more logical that could make this a more legitimate transfer of estate property? And so, Weiss touches on that in Trustees in Commerce. He talks about the sovereign, he talks about the trustee and how the trustee can operate. And it's very clear and simple. You can appear as the trustee for the trust that holds a priority security interest in the debtor. And the debtor never has to appear. Or would it be, it would be probably a little easier to have a second trustee appear for you, which is why we chose to place this in effect. We chose to execute this webinar series so that people can learn to truly trust each other, so that when it's time to go to court and there's a charge that's been offered here, a trustee can walk in, place a notice of interest stating, hey, I have a priority security interest in this. I've not been noticed of this case. I want to have this case dismissed because I have a first in line lien against this person. this real person that you are charging, and I'm a real, separate, special purpose vehicle with real interest that has been filed and published and noticed in the public. So,
That's great. I've whether it's the UCC one filing or a court appearance, um, these are both times when you want public notice taken of the relationship between the person, and it's not actually the living man. It's actually uh, the upper and lowercase name, which is a private trust.
well,
Okay.
for the sake of my conversation, if you could place the uppercase as the taxpayer or the person and the lowercase as the living man, I'm using those
I know.
personifications to speak clearly. That way we understand, because once again, like you say, a lot of these words get taken out of context, and people could think that that's exactly what I mean, that it's, that that's the living man, and I'm just using it as a personification to explain I am, so please, I'm
Okay.
sorry. Yeah.
I understand. Now, what I'm going to do is talk about what it really is, and the reason for that is that it's the same thing that we're doing with the trust. Okay, there's a public trust that's being liened by a private trust. Okay, that's what's going on when the living man liens his person. Okay, and I'm not going to say whether that works or not because there's evidence on both sides. I've seen it work and I've seen it not work. Okay, that there are mortgage cases that are held up when someone liens his person, and the you know and it goes to court because the bank can't sell the house because the house is listed as collateral. Okay, and then there are mortgage cases where someone liens his person and it makes no difference. They steamroll right past it. Nobody notices. Nobody cares. Okay, so I've seen evidence on both sides of whether that works, and the same in court. I've personally gone into court many times differentiating myself from the person, and I've seen it work one day and get thrown out the next appearance, and then work the next time I'm in on the same case. When I say thrown out, I mean the concept, not the case. It's a very, very tricky thing to do, and as Weiss says, it makes you look a little crazy, and it puts you in a position of potentially having to argue your position because the judge might think either you're crazy or he doesn't know what you're talking about, or he's going to test you to the max to see if you do know how to hold your mud in the stance that you're taking, which is a very, very difficult one to stand on for the simple reason that the names are the same. Okay, you can differentiate them as much as possible. I'm John Adams of the Doe family. Okay, well, are you John Doe? Well, uh, you know, Your Honor, you may call me John Adams. What's your last name? I don't have a last name. I have a family name. It's Doe. But it's a very tricky thing to walk around, and it's just it makes you look a little crazy. It makes it too easy for the court to make you look crazy and to just dismiss you, and there's no need for it. When you know it should be legitimate, in my opinion, it should be legitimate to lien your person or to differentiate yourself from the person, both on a UCC1 and in court, because it's a public trust liened by a private trust, then it should be doable. But if that private trust had a different name and trustee, you'd be in way better shape. Like there just wouldn't be any question. All this, what is your name? Who are you? All of this wouldn't be going on in court. Or, in the case of the UCC, it couldn't be just dismissed out of hand because it's the same name.
Yeah, it would be, Jerry Beheimer, trustee of ABC Trust, priority security interest holder, noticing the court or petitioning the court. in some form or manner, and they'd have to hear that because it's a third party intervener. It's an interested party.
It is the interested party.
Yeah, it's a
Yeah.
real party in interest, is what it is, and they have proof that they're a real party in interest by way of their public financing statement against whatever property or chattel is being encumbered at this moment, and they have a right to ask that to not happen.
Right. So
Similar to how a second lien on a home cannot be collected until the first one is.
right.
Very simple. And to add to what you were saying a little bit earlier, in some of the failings, a lot of the failings has nothing to do with the trust, but rather sometimes how the property was transferred. Sometimes property was transferred accordingly. Sometimes it wasn't. Oftentimes in the mortgage industry, people get a little, or in the mortgage issues, they get a little desperate, and one would fraudulently transfer a property thinking that it would. That it was free and clear and that the lien was gone, transferring it then to a trust, and that trust then being called into question for what's been a fraudulent transfer, a fraudulent acceptance to the trust. So that's when all of a sudden now the private trust fails, everything fails because it's all been called into the jurisdiction, all because there was a previous lien or previous contract that was involved that didn't handle things. And those are just simple ways that these things falter, which is why we brought up in our first few webinars, Fraudulent Transfers Act, perpetuities, the things that you could easily loophole yourself in just because it wasn't pointed out to you. So, but I think we should maybe.
And there's one other trap that goes with this. There's one other trap that goes with this as well. In trying to distinguish the living man from the person, and this is again the court example, not UCC, but they kind of go hand in hand. If you're trying to operate that way, then it's on your paperwork and it gets tested in court. Okay, and if you get to court with it, the problem comes about when you, the living man, distinguish yourself from the person. Then what is your relationship to that person? And it's easy to overlook the debtor-creditor relationship because it's the same name. So at best, the judge might accept that you are agent for, which he'll try to turn into trustee for that public trust, that public person. And as soon as you become, in his eyes, the trustee for that public person, then you're doomed. Because guess who pays the bills, pays the debts in the trust relationship? The trustee. Trustee always pays the bills. So if the judge believes that okay, fine, he accepts that you're not the person, okay, that's a public trust, it's an ens legis, and you're there on behalf of that. Okay, great. So you're the trustee then of that public trust. If you agree, then he says, okay, great. Then here, pay the prosecutor.
Well, when you have, what the trust, and I think I'm starting this wrong. When that circumstance is happening, and by the way, I know the question is going to come up. When would we ever be in court? Well, often we're offered charges all the time. We're offered all sorts of fun offers to go to court, and so you never know where you're going to be or what's going to happen. But if the property that's being encumbered or is accepting a charge or is attempting to accept a charge has been encumbered, then it is the responsibility of the secured party to protect the interest from being encumbered. And that would fall on the trustee of the private trust having a lien against the person to step up and place in a notice of interest and an entry of motion to dismiss based on grounds of lack of personal jurisdiction or grounds that they have no higher case and that there's nobody there to rebut their claim that they have a higher case and that it must be dismissed. And that gets back to what Winston used to say when you'd walk in and say, he would say things like, I'm the super plaintiff, or I'm here with a priority claim, the highest claim in this court. Can anybody rebut my claim and have this dismissed? Now, once again, we're falling into the same hole. If it's the person, the judge is just going to keep you there, and nothing's going to happen. Christian, you've walked out of court, haven't you? after you stated your claim.
Oh, yes, I have.
Yeah, yeah. So maybe you tell a little about that, just to explain that,
Yeah.
these things happen. They just sometimes the judge is like, "What was that? I don't care. I call the shots here."
Oh yeah, I've definitely had a judge just yelling at me. I mean, just irate, just going. I mean, his blood was boiling, and he's like, "Who are you? I need a name."